Uzelak and Larry Teal.
And Don Godwin, Your Honor, for Gail Fischer, joined by Morgan Scott and Kristen Burns.
Your Honor, this is Alan Lowenson. Are you able to see me? Because I'm seeing everyone but myself, which is great. I don't want to see myself, but I want to make sure you're seeing.
I'm sorry, who said that? Mr. Lowenson? Yeah, we can see you fine.
Okay, great. Thanks.
Actually, Mr. Lowenson on my screen has the center box. He's Paul Lynn in the Hollywood Square.
Lowenson for 20.
I thought Alan was standing on a box there, Larry. I mean,
it's a soapbox, Don. I borrowed yours.
All right, let's get started, guys.
Your Honor, let me, before we start, let me say a couple things. Number one, we would like equal time today.
Okay.
So I know Mr.
Why don't we do this? I'm going to give each side 30 minutes to do their initial argument, and then we'll.
I'm going to need more than 30.
Well, Your Honor, may I say I'm going to only need 15, so I'll yield 15 to Mr. Roberts.
Well, that's fair, Your Honor. I mean, I don't know that it's fair that if Seymour have 45 minutes and they tell me I'm only going to get 30, I'm the one that's been ganged up on here today by all these lawyers and parties. And so I think I ought to have the same amount of time as all of these guys. And so I would think that 30 minutes would be ample time for me, 30 minutes for Seymour, and 15 for Allen. If I need 5 minutes more because I got a group there to go against, that is Seymour and Allen, I would think maybe I could have 35 if I need it. I may not need it, but I certainly don't want to see Seymour get 45 minutes plus and me be limited to 30.
Well, 30, 30, and 15 is fair. I just don't want to have an hour and 30 for Mr. Godwin and then 30 and 15. So as long as we know where we're starting, that'll be fine.
So, Ms. Jones, we're going to start off. Mr. Godwin will have 35 minutes. And Mr. Friedman will have 30 minutes, and Mr. Lowenson will have 10 minutes.
Thank you, Your Honor.
Okay.
All right. So
Judge, before we begin, my paralegal's having some trouble sharing on her screen.
Well, the clock's running, so.
All right, let's get started.
Okay. Judge, Albert Einstein once defined insanity as doing the same thing over and over again and expecting different results. And according to this definition, what we're witnessing here is insanity. Gail keeps litigating the same issues over and over again. If she litigated them in a divorce action, she can't now litigate them in this new lawsuit. And as a postscript, she appealed the divorce decree and lost every single one of her points. Our memorandum opinion on that, the Court of Appeals, is our Exhibit 52. Besides trying to litigate here in the new lawsuit, issues that she actually did litigate in the divorce action, Gail is trying to litigate issues she could have and should have litigated in the divorce action. She is trying to circumvent the divorce decree by litigating issues she had every opportunity to litigate in the divorce action. And she's trying to undo the tactical strategy decisions she made during the divorce trial. The law does not allow her to do that. There are multiple doctrines of preclusion, which is our slide 2, which apply here to stop Gail from doing that. The alleged claims that should be the subject of summary judgment, I need slide 2 now, are Gail's alleged claims that predate the signing and rendition of the divorce decree, Gail's alleged claims that accrued after the execution and based upon the compensation and control agreements, and Gail's alleged claims that accrued after the execution and based upon the agreement to convert and the voting agreement. Cliff is entitled to summary judgment as a matter of law under the doctrine of compulsory counterclaims. They are governed by Rule 97A. They must arise out of the same occurrence or transaction as the subject matter of the opposing party's claim. Does not require the presence of a third party over which the court cannot acquire jurisdiction. must be filed in the first action, cannot be filed in the later action. The failure to file the compulsory counterclaim in the first action bars it being litigated in the later action. The purpose of the compulsory counterclaim is to dispose of all claims in the same transaction or occurrence and avoid multiplicity of litigation and inconsistent results. Counterclaim factors are within the jurisdiction of the court. It is not at the time of the filing of the answer the subject of a pending action. The claim must be mature and owned by the defendant at the time of the filing of the answer. It arose out of the same transaction or occurrence that is the subject matter of the opposing party's claim. It is against the opposing party in the same capacity, same transaction, and does not require the presence of third parties over whom the court does not have jurisdiction. All compulsory counterclaims are met here. Gail is alleging fraud and breach of fiduciary duties in this new lawsuit. Count 1 is breach of fiduciary duty. Count 5 is fraud. Count 6 is a fraud. Count 7 is fraud. Count 9 is conspiracy based on fraud. Count 11 is declaratory judgment based on fraud. Fraud and breach of fiduciary duty allegations are alleged in all of Gail's claims. You can compare Gail's language in her counterclaim response, which is our Exhibit 29, with the language in the Fourth Amended Petition, which is our Exhibit 34. Gail's claims against Cliff were within the jurisdiction of the trial court, the 254th, which was hearing the divorce action. The 254th is a family district court and has the jurisdiction to hear the claims Gail alleged in the new lawsuit. The jurisdiction of family courts is governed by Section 24.601 of the Texas Government Code, which
Mr.
reads...
Roberts, this kind of leads to my first real concern here, which is given the Court of Appeals decision and the transfer motion, did the family court have jurisdiction over the Gail Roberts claims? It seems like maybe they didn't.
Well, Judge, what I was going to show you is that here, under the government code, a family court has concurrent jurisdiction with all other district courts. It can hear any claim. It has concurrent jurisdiction.
I don't necessarily disagree with you, but how do you reconcile the opinion? And that's why I thought that Judge Wysocki was correct in transferring this back to the district court or to her court. But the Court of Appeals disagreed. I obviously have to follow the rulings of the Court of Appeals. How do you distinguish that opinion where it said that she didn't have jurisdiction over these matters and argue that she would have jurisdiction? You're basically telling me to ignore, I think, the Dallas Court of Appeals decision.
Oh, no, Judge. I'm not doing that at all. The Court of Appeals is saying that because those claims weren't brought in the first instance, they have to be brought in your court. The Court of Appeals wasn't saying those claims could not have been brought in the first instance. The Court of Appeals was saying because they were not brought in the first instance, when they are going to be brought, they need to be brought to you because they weren't a part of the divorce when the divorce was litigated.
Well, why though? I mean, why if they have jurisdiction, why couldn't it have been brought in that court?
I think what the Court of Appeals was saying was that because we are now post-litigation, we're post-judgment, the only thing left for the court, for the divorce court, is enforcement of the decree and contempt under Chapter 9 of the Family Code. That's the only thing that is left. Had these issues been...
But under the related case transfer doctrine in Dallas County, if they had jurisdiction, clearly these were related cases. It should have been transferred back to that court unless that court doesn't have jurisdiction over civil matters.
Well, that is what we argued, Judge, but I think what the Court of Appeals...
They didn't agree with you, though.
No, they did not. And I think the reason they didn't agree is because these issues were raised post-judgment.
Why does that matter with the related case? We have cases that are closed that still get we have a non-suit in the first case on a case that's purely been closed, completely been closed. You can still transfer from one civil district court to another, even if the first case is closed. Why is that relevant in this inquiry unless the family court didn't have jurisdiction, according to the Court of Appeals, of the first case.
Well, I don't
Of
think
the matters related to here vis-a-vis the first case.
in looking at the pleadings that were before the Court of Appeals and the Court of Appeals decision, I don't think the issues that we were talking about were briefed and ruled on by the Court of Appeals. I think the Court of Appeals took a look at what was going on, which was the theft of the $5 million, and said, no, it's got to be in front of Judge Hoffman, because it had nothing to do with the divorce.
So what you're arguing, they said it just wasn't related?
The $5 million issue, which is really what is before you and we can't have in front of the Court.
Can you share screen that opinion so we can kind of go through it? Because I think it's critical to our analysis here.
Okay, sure. I mean, that is going to be it's one of our later exhibits. And that is going to be, Marion, if you could bring up memorandum opinion is that's going to be exhibit 41, which is the memorandum opinion. Marion, if you'll bring up exhibit 41, the memorandum opinion on the writ of mandamus.
Give me one. I'll bring it up.
If you could tell me the page, page 501, okay.
Go to the part where it discusses the transfer.
Okay. Let's go further. Okay, go up a little bit.
Well, go up.
Over here? Or
Yeah, that's it.
Okay.
So it says, but neither this court, if you go to the second paragraph, but neither this court nor the Texas Supreme Court has held that sections 24.601 permits a family court under the Family Code, Chapter 9, to hear cases involving issues other than those related to the division of the marital estate. How do you reconcile that they would have I mean, assuming that I have to follow this, so.
Right.
How do you say that the family court would have jurisdiction given and I don't disagree with your analysis of that, the language of the government code, but I have to follow the analysis of the Dallas Court of Appeals and the Supreme Court.
I understand that, Judge. And what I would point out to you is that if you look at Gail's allegation in her breach of fiduciary duty claim, she is suing Cliff in the marital capacity. Okay, this deals with a divorce action.
So she doesn't have an ownership interest. Her only ownership interest in the company is because that she's married to Cliff. It's not because she has her own independent ownership interest in the company.
She has a separate property. She has, at the time of the divorce, they had entered into an agreement to convert. And she had a community property interest in 50% of the company's stock. And when she sued Cliff in your court, in her breach of fiduciary allegations, she raised the point that she was suing him in his marital capacity. You can see that actually in one of our in our exhibit 4, because we
So
have that up.
All of the claims, Mr. Roberts, that she's making in this case are related to the division of the marital estate.
Well, I think they're related to it, and here's why. she not only is suing Cliff in Cliff's marital capacity in your court, but she sued Cliff in his corporate capacity.
So if that's the case, then why didn't the Dallas Court of Appeals transfer this case back to the family court?
Because I don't think it was briefed and brought to their attention. The issues, the allegations that we're making, the legal analysis that we're making wasn't before the Court of Appeals.
Okay.
She is suing Cliff in your court, and not only in his corporate capacity, but in the marital capacity. And she sued Cliff in the family court, both in the marital and in the corporate capacity.
So
that's why res judicata and compulsory counterclaims apply. There is the same capacity.
The original court has to have, for all of these preclusion doctrines, the original court has to be able to have jurisdiction over the over the claims, correct?
That is correct. And the claim had it, because what happened in the family.
You've argued here that the marital estate, that some of these claims, I'm not sure if I agree with you, but your argument is some of these claims arise out of her status as her marital status, and some of them arise out of her corporate status. Is that what your argument is?
My argument is
Seymour. I think we're confusing three arguments. Number one, the Court of Appeals decided which of the cases should hear which of the different claims that were pending at the time. Both courts had concurrent jurisdiction, but because there was intertwining of family law matters and strictly civil matters, the Court of Appeals just sorted that out. Court of Appeals didn't address whether these claims had already been brought in prior proceedings. That's why we're here today. Because the reason we're here today is because these very same claims between the very same parties have already been adjudicated in a different court, previously in a different court. And Gail doesn't get a chance to litigate these same claims twice. That's why we're here.
Okay. All right. But the original court had to have had jurisdiction. And I think that's what my concern is here, is that did the family court, and maybe they did have jurisdiction over some of these claims, at least as to the compulsory counterclaim, you'd have to show that the original court had jurisdiction over these matters. But all right, so Mr. Roberts, you can proceed.
Well, but let me address that. Not only did the original court have jurisdiction because it was a district court, the parties entered into an agreed judgment and had jurisdiction by agreement. So yes, the original court had jurisdiction.
And that raises another issue, is that did the agreed judgment specifically dispose of, I guess another issue would be, at the time that the agreed judgment was made, were these claims, which of these claims were currently pending in the family court?
Well, Judge, sorry, go ahead.
All of them. Isn't that correct? Seymour and Alan?
Well,
yes,
Your Honor, I was there, so.
Yeah, I was going to say Alan was there. Maybe Alan can address that.
My understanding is the time we reached, which I participated in the agreed judgment, because I was representing the company, nothing had been dismissed. Every claim that had been made was present at the time. And Gail had filed a claim against the company, or had sued the company. The company had counterclaimed, seeking a declaratory judgment, or that all these executive agreements were valid and enforceable. And then we entered into an agreed judgment that in fact they were enforceable. And it was at that point that the company was, I think it was dismissed from the lawsuit pursuant to the agreed judgment. But whatever was existed at the time of the agreed judgment. That answers Your Honor's question.
All of the claims that you were seeking res judicata on in this case, or collateral estoppel or whatever, all of those claims were pending, if I understand what you're saying, in the family court when the agreed judgment was made.
I think I would say it's slightly different, but I think we're getting to the same point, and I'm jumping a little bit into Seymour's, but it does relate to my clients. All of the claims that we, both Mr. Roberts, Mr. Freeman, and I, for our respective clients, believe give rise to these preclusion doctrines, all of those claims were extant. They were existing at the time the agreed judgment.
Were they, okay. Maybe we're passing ships in the night. Were your clients, Mr. Lowenson, even in the family court?
They were not, which is why in my turn, I'll be arguing the issue of privity with your honor. They were not parties, but under the preclusion doctrines, they don't need to be if they were in privity. And that's the portion I'll be spending my 10 minutes on.
Okay. All right. Let's proceed.
Okay, Judge. I want to point out that Gail sued Cliff in the marital capacity in the family court. You can see that in our slide number 4, where she says, Cliff Fischer especially owed Gail, next slide, Miriam. Cliff Fischer especially owed Gail Fischer a continuing fiduciary duty due to their marriage, and to make full and complete disclosure. With that quoted language from the Fourth Amendment petition, Gail was suing Cliff in his marital capacity, and she sued Cliff in his corporate capacity in the divorce action. You can see that in our next slide. Because when Gail alleged Cliff had violated his fiduciary duties to her in her counterclaim response, which is our Exhibit 29, in the divorce action, she made those allegations against Cliff in his corporate capacity as the company's CEO. As you can see from these allegations, there's no dispute that Gail is talking about Cliff breaching his fiduciary duties to her in his corporate capacity, and this was filed in the divorce action. Let's look at the same transaction test for res judicata and compulsory counterclaim purposes. That means that the same transaction or occurrence must be logically related in time, space, origin, and motivation, form a convenient trial unit, conform to the party's expectations. There must be a legal relationship as per a contract or a lease. Cliff sued Gail for fraud or breach of fiduciary duty in the divorce action counter petitions, which are our exhibits 13, 14, and 15. That was the time for Gail to counterclaim against Cliff for fraud and breach of fiduciary duty. Gail's alleged claims for fraud and breach of fiduciary duty in the new lawsuit here arise under the voting agreement and compensation and change and control agreements. She is alleging here, Judge, in your court, for example, that Cliff had intrinsically and extrinsically defrauded and fraudulently induced her to enter into it. But if you look at what she said in the family court, it's a completely different matter. She entered into an MSJ order, which is our exhibit 17, that held that the agreement to convert that attaches the voting agreement was valid and enforceable. And if you look at the language in the voting agreement itself, Judge, it says a number of very telling points, which is our next slide. She is claiming that I have carefully read each and every page. I am fully and completely informed. She enters the agreement voluntarily. She gave careful and mature thought. And this is the best part. I further acknowledge that the agreement was not procured by fraud, duress, or overreaching. I am not relying on any fiduciary obligation owed, not relying on a confidential or other relationship, not relying on any accounting or legal advice provided by Cliff. And she agreed that she would be stopped. These are her words. She would be stopped from making any claim of any kind going forward. Cliff sued Gail for fraud and breach of fiduciary duty in the divorce action, but Gail didn't counterclaim. She waited until the entry of the divorce decree and then filed this new lawsuit. Gail's failure to timely file her compulsory counterclaims for fraud and breach of fiduciary duty mean that those claims are barred. And that's the same point about res judicata. It should bring an end to litigation and vexatious litigation. It should maintain stability and promote judicial economy and double recovery. Res judicata has 4 factors: a prior final judgment entered by a court of competent jurisdiction, same capacity, issues that were or could have been raised. And all of those issues are present here. We have a divorce decree that is a final judgment. In fact, we have an agreed judgment that was incorporated into the divorce decree. We also have the MSJ order on the agreement to convert that was also incorporated into the divorce decree. The divorce decree disposed of all of the issues of all of the parties. You can see that up there. It disposed of all issues of all of the parties. Gail's alleged claims in the lawsuit were either raised, could have been raised, or should have been raised there. And again, whether res judicata applies depends upon the same transaction test. It's the same formula as under the compulsory counterclaims. In the new lawsuit, Gail is alleging fraud and breach of fiduciary duty, improper shareholder distributions. She's challenging the compensation agreements and the voting agreement. The operative facts being litigated here either were or could have been litigated in the divorce action. Again, the agreed judgment regarding the divorce decree is incorporated in the divorce decree, as is the MSJ order. With the exercise of due diligence, Gail either or could have raised the matters in the new lawsuit, and her failure to do that is fatal for res judicata. Same is true with collateral estoppel. It prevents inconsistent judgments by precluding relitigation. The factors are: the facts sought to be litigated in the second action were fully and fairly litigated in the first action. The facts were essential to the judgment and the parties were adversaries. There must, of course, be the same capacity. Each collateral estoppel factor is present here. The documents and claims being litigated in the divorce action and the new lawsuit are the same. It's the compensation agreements, the agreed judgment, the agreement to convert, the voting agreement, the MSJ order, fraud, breach of fiduciary duties. It's the same. The facts sought to be litigated in the second action, your new lawsuit, were fully and fairly litigated in the first action, divorce action. That was the legality and enforceability of the compensation agreements, the legality and enforceability of the agreement to convert, any alleged fraud, any alleged breach of fiduciary duties. These were fully litigated in the divorce action. This can be seen by the entry of the MSJ order. These issues were raised in Cliff's 3 amended counterclaims. These issues were raised in Gail's business counterclaim response, which is our Exhibit 29, and that's our slide 8. You can see there that she's alleging claims against Cliff for breach of fiduciary duty in his corporate capacity. The facts were essential to the judgment in the first action. After pleading and litigating the business defendant's counterclaims and Gail's counterclaim response, Cliff and Gail entered into the agreed judgment, and Cliff filed his divorce court MSJ, and Cliff and Gail entered into the MSJ order regarding the agreement to convert. This shows that the underlying facts as to the validity and enforceability of the compensation agreements and the agreement to convert and the voting agreement were all essential and litigated in the divorce action. The new lawsuit directly contradicts what has already been litigated. Cliff is entitled to summary judgment because of judicial admissions. A judicial admission is a formal waiver of proof. There's no need to produce evidence on the issue. There's no dispute allowed. The statement binds the declarant. It's absurd and unjust to allow a party to recover after the party has swore itself out of court by a clear and unequivocal statement. Those factors are a statement made during a judicial proceeding that is contrary to an essential fact or defense asserted by a person making the judicial admission. It is deliberate, clear, and unequivocal that if given conclusive effect would be consistent with public policy. and that is not destructive of the opposing party. All of those factors are present here. Gail has made judicial admissions in the agreed judgment and in the MSJ order. Each of those statements were made during the course of the divorce action. They were all contrary to what Gail is claiming here in this lawsuit. They were all deliberate, clear, and unequivocal. They are consistent with public policy and not destructive of Cliff's theory of recovery. Under the rule of judicial admissions, an agreed judgment establishes the issue in question as a matter of fact. A party is not permitted to agree to a judgment and then later file a new lawsuit disputing the facts recited in the earlier judgment. A party is barred from attacking an earlier agreed judgment, and we have several agreed judgments. We have the agreed judgment regarding the compensation agreements, and we have the MSJ order. Gail should not be entitled to enter into those agreed judgments and file the new lawsuit. Quasi-estoppel applies, and that's a specific legal bar. It precludes taking contradictory positions. It stops a party from asserting to another disadvantage or right inconsistent with the right previously taken. It applies when it would be unconscionable to allow a person to maintain a position inconsistent with one she previously acquiesced. You need a previous action and a subsequent inconsistent position. Gail has acquiesced to the agreement to convert, to the MSJ order, to the agreed judgment, and to the divorce decree. Gail has acquiesced to the divorce decree by relying on it on her contempt motion, which is our Exhibit 45 and filed in April of last year, where she is attempting to hold Cliff in contempt by allegedly violating some of its provisions. Gail cited that contempt, the divorce decree, and relies on memorandum ruling opinions in the divorce decree. Gail acquiesced to the divorce decree when she invoked the divorce decree at a meeting of the company's shareholders. The company had a shareholder meeting in December of 2019. The company's shareholder meeting was recorded, and we have the transcript at our Exhibit 46. The company's shareholder meeting was called for the purpose of considering Cliff's amendments. Larry Teal was present at the shareholder meeting to be the tie-breaking vote under the voting agreement. But Gail relied on the divorce decree to argue that the amended voting agreement was no longer in effect. Gail acquiesced to the agreement to convert and the MSJ order. This can be seen in communications from Gail and her counsel, informing the reader that Gail was a 50% owner of the company. That is our Exhibits 2, 7, 8, and 9. There are examples of Gail taking inconsistent positions against the agreed judgment, the divorce decree, and the MSJ order. On the one hand, Gail entered the agreed judgment on the other, and the MSJ order. And she has a lot of, there are rulings and admissions, but here she's challenging them. Cliff is also entitled to summary judgment under the doctrine of estoppel by contract, which is a form of quasi-estoppel. It is based on the idea that a party to a contract can't take a position inconsistent with a contract and then deny its full force and effect. It binds a party to the terms of her contract unless the contract is void or annulled. In this new lawsuit, Gail is taking the position that is inconsistent with a voting agreement. She's claiming that she was defrauded into entering into the voting agreement. But if you look at the voting agreement, and again, it's up there on the screen, she's saying the exact opposite. She read every page. She was completely informed. She entered into it voluntarily with clear and careful and mature thought. There's no fraud. These are her words, Judge. No fraud, duress, or overreaching. She's not relying on any fiduciary obligation. Again, her words, and that she would be estopped in the future. Those are, again, her words. Cliff is entitled to summary judgment under the laws regarding a bill of review. A bill of review is the exclusive method to challenge a final judgment after the time to appeal or file a motion for new trial expires. It is a direct attack on a final judgment. It must be filed in the court that rendered the final judgment. If the bill of review is not timely filed, the court has no authority to declare a judgment void. Gail appealed the divorce decree and lost, but Gail did not appeal the agreed judgment. She did not appeal the MSJ order. She did not file a bill of review. Mr. Godwin raises the specter of a stipulation, but there is no stipulation that Gail's alleged claims against Cliff for breach of fiduciary duty are not barred by the preclusion doctrine. Gail's counterclaim response in the divorce action show that Gail's alleged that Cliff violated his fiduciary duty to her. And Gail contends that during the trial of the divorce action, Gail reserved her right to sue Cliff for breach of his fiduciary duty in a separate stipulation. I have three things to say to that. First, whatever was said on the record was merged into the signed agreement, which was the agreed judgment. And the alleged stipulation is not in the agreed judgment. It was merged into the agreed judgment. There's nothing in the agreed judgment that's a stipulation. The parties documented what they told the court. Gail reserving her right to sue Cliff was not in there. Therefore, there is no such stipulation. Second, there's no evidence of a stipulation. Cliff's lawyer, Mr. Epstein, did not agree that Gail could reserve that right. There is nothing like that on the record. The court may have asked about the reservation of rights, but that is not enough to have a stipulation. Finally, there is no stipulation that the preclusion doctrines do not apply to Gail's breach of fiduciary duty claims being brought after the trial of the divorce action, because parties cannot stipulate to how the law applies to agreed upon facts. When entering into a stipulation, the parties may only stipulate to certain facts. They are not allowed to stipulate as to conclusions of law or the legal effect of stipulated facts. A court is not bound to accept stipulations of law by the parties. Such prohibited stipulations are without effect. Here, Gail claims that her counsel in the divorce action during the trial of the divorce action reserved her right to sue Cliff in the future for breach of fiduciary duty. Assuming arguendo that is true, and we do not, the only thing that was stipulated was Gail's timing. What was not stipulated was the legal effect of the stipulated facts. In other words, even if Gail thought she had stipulated that she could sue Cliff in the future, that alleged stipulation did not preclude the application of the preclusion.
Mr. Roberts, your time is up.
Thank you, Judge.
All right. Mr. Lowenson?
Yes, Your Honor, on behalf of defendants Ted Uzelak and Larry Teal, the undisputed summary judgment is that my evidence is that Ted Uzelak was Executive Vice President, Chief Operating Officer of the Fischer Company. I'll refer to as the company from November 1, 1996 to July 29, 2001, and President of the company from July 30th, 2001 to the present. Larry Teal, also an officer of the company, served as Senior Vice President, Executive VP from March of 94 through September 2001, and then from November 2014 to the present Vice Chair of the Board of Directors. All of the claims that Gail asserts against my clients are barred by the doctrines of res judicata, collateral estoppel, and/or judicial admission and a right for summary judgment. Cliff and the company have asserted those same three grounds. The vast majority of the arguments that Gail has made in response to our motion were also made in response to Cliff and the company's motion, which I believe have been adequately addressed in briefing and in argument. So I'm only going to focus my presentation on the arguments that were specifically made in response to Teal and Uzelak that do not apply to the company and therefore were not addressed by them. Before I get into substance, I want to make one overarching comment. Gail responds to our motion saying there must be a fact issue because we filed over 300 pages. A misleading statement at best. The motion was only 23 pages, addressed 3 legal doctrines. The remainder of the approximate 300 pages were simply exhibits consisting of pleadings and judgments for the courts. So let's start with res judicata. The primary difference in Gail's response to our motion versus her response to Cliff and Gail's is with respect to the second element of res judicata, the identity of parties. With respect to the second element, the parties to the two suits do not have to be identical if the parties in the second suit are in privity with a party to the prior judgment. A party who is so connected with a party to the prior judgment that the party, as a matter of law, represented the same legal right. For purposes of res judicata, this identity of interest exists when, and I want to focus on the second element, 2, the party to the prior action represented the person's interests. Those elements, including the second one, are set out in the very important case cited in our motion, Better Business Bureau of Metropolitan Homes versus John Moore Services, 500 Southwest 3rd, 236, petition denied, which conspicuously Gail does not even address or mention in her response to our motion, but is very instructive. In Better Business Bureau, a couple of entities collectively referred to as John Moore sued the Houston Better Business Bureau in a state court suit. John Moore attempted to amend their petition to add individual members of the board and its president, and the court struck the amended petition in the first suit. The first suit was later dismissed by a motion to dismiss. Then John Moore subsequently files a second state court suit, asserting various causes of action against the Better Business Bureau, but this time adding the individual officer and board members in both their individual and official capacities. The court notes that with respect to the Houston board president and board members, we apply the general rule that the actions of a corporate agent on behalf of the corporation are deemed the corporation's acts. The court found that for these individual defendants, the evidence establishes an identity of interest. The court explained that although John Moore has sued the individual defendants in their individual capacities, its allegations in the suit against them arise out of their conduct as officers or directors of the Better Business Bureau. As board members, the individual defendants were in a position to control the positions taken by the board in the first suit. Therefore, there is an identity of interest, and we conclude these defendants have satisfied the identity of interest element, and the claims against the individual officers were dismissed under the doctrine of res judicata. As in the Better Business Bureau case, here, Uzelak and Teal are in privity with the company, who was named as a defendant in the divorce action, because their interests were represented by parties to the action. The undisputed summary judgment evidence establishes that Uzelak as COO and Teal as EVP and board member had been officers predating the divorce action even being filed. They played an active role in preparing and shaping the company's defense of the divorce action, and they are in fact directly mentioned by name in Gail's response to the business defendants' counterclaims that were filed in the divorce action.
Just to be clear, they were never parties in the divorce action.
Not named as parties, just as not in the Better Business Bureau were not named as parties. In the
And
first
so the argument that was made by Mr. Roberts that, well, even if the family court didn't have jurisdiction over this, there was an agreed judgment that covered all of the claims, that wouldn't apply to your clients, correct? Because your clients were not parties at that point.
No, that's exactly my point. It would apply because my clients had an identity of interest with the company and were the officers of the company, and they were the parties to the
So
document.
it doesn't matter that the family court may not have had jurisdiction over claims against them.
No, the issue is, do they benefit as parties in privity with a party who was a party to the action? And I'm aware of no law that says that the first case had to have jurisdiction over the parties who are in privity. As long as they are in privity, they benefit from the preclusion doctrines. And Mr. Godwin has cited no law to the court saying, well, you first have to show that the first court would have had privity, because the issue is not where the,
You mean the first court would have had jurisdiction?
I'm sorry?
You said the first court would have had privity. You meant the first court would have had jurisdiction.
Yes. And the reason is because the issue is not, should you have brought the individuals who were in privity into the first case, and because you didn't, you are precluded, i.e. the normal compulsory counterclaim rule. The issue is simply, if the parties to the first case, if my clients are in privity with them, then they, as a matter of law, benefit from the preclusion doctrines. And so I don't think jurisdiction would have been an issue. Now, Gail attempts to respond to the privity argument by arguing that Gail is somehow suing in a different capacity in this lawsuit in the divorce case. And then she says that what you just asked, she says, well, Uzelak and Teal were not parties, but that's not our position. Our position is that they were in privity. And here's the important point. Gail admits in her petition in this case that the actions taken by Teal and Uzelak were done in their capacity as officers of the company. I'm going to share screen with you and point out a couple of provisions in her latest amended, or in her fourth amended petition. Tell me when you're ready. In the introduction, she says, this is an action against a certain shareholder, which is Cliff, and other executive officers of Clifford, Fisher and Company, which are my clients. Paragraph 11. Uzelak is, and is at all relevant times to this petition, the president of the company. Paragraph 12. Defendant Teal is, and at all times relevant to this petition, the vice chairman of the board of directors and executive vice president. Then if you go to paragraph 23, in the middle of the factual allegations, for the last couple of years, Gail Fisher concerned that the defendant officers were hiding information. Then if you go to the causes of action, count 1, breach of fiduciary duty against the defendant officers. You go to paragraph 43, the defendant officers provided excessive compensation. Paragraph 45, in addition to such grave misconduct by the defendant officers. Paragraph 47, the defendant officers have engaged in actions, and then she goes on to explain what the actions are. Paragraph 48, the defendant officers have violated their fiduciary duties to Gail Fisher. Count 2, conversion of Gail Fisher's property against the defendant officers. Paragraph 53, defendant officers have unlawfully assumed and exercised dominion and control over Gail's property. Paragraph 54, defendant officers' adverse and destructive actions. Paragraph 55, defendant officers' unlawful actions. Count 5, the next to last count against my clients, wrongful fraudulent transfer against defendant officers. Paragraph 68, the defendant officers have transferred. Count 9, the last count against my client, conspiracy against defendant officers. Paragraph 91, upon information believed defendant officers have conspired to commit. So following the Better Business Bureau, these are actions taken allegedly in their role as officers of the company. And to use the language of the Better Business Bureau case that I referenced to the court, the actions of a corporate agent on behalf of the corporation are deemed the corporation's acts, and therefore they are in privity. So for all the reasons that you hopefully have read about, and I'm sure have read about and have heard about with respect to the company and Cliff, why res judicata applies, assuming you reach that conclusion, my clients benefit from those doctrines under the privity doctrine. The same is true under the doctrine of collateral estoppel, because again, the only difference in her argument, in response to our argument, in her argument to the company and Cliff, is the issue of privity, and I've addressed the issue of privity. And then lastly, the doctrine of judicial admission, her argument is entirely duplicative there, and therefore the argument would be exactly the same. So I'm not going to repeat, although I do agree with the arguments with respect to why the conclusion doctrines apply. But if the court reaches that conclusion under the doctrine of privity, then my clients benefit from those and should also be dismissed. Thank you, Your Honor. Unless you have any questions, that's all I have.
Mr. Godwin.
Thank you, Your Honor, and I will address both of Seymour's, Mr. Roberts and Mr. Lowensen's arguments all at the same time as I go through. Judge, it's if I've ever seen a case where the theory of let's throw it up against the wall and see what will stick, if I've ever seen one that evidences more of that that is going on, it is right here in this case. When you hear these things, and when you hear Larry Teal and Ted Uzelak talk about res judicata, and that they should be granted summary judgment when they weren't even involved in a divorce action, it's just ridiculous on its face. But having said all of that, Your Honor, I'm going to go through now the arguments that I want to present. Cliff Fisher, who I will respectfully refer to from time to time as Cliff in the argument here, Uzelak and Teal, and the company, they continue to acknowledge and highlight to this court that the divorce proceeding dealt with the divorce between Cliff and Gail. Yet they still seek to claim that the corporate claims are barred by res judicata and other preclusion doctrines. However, in Gail's and Cliff's divorce, Gail never pursued any causes of action against Cliff, Usilac, Teal, or the company. Gail's pleadings in the divorce action were limited only to the division of the parties' marital property, their estate, did not address any of the claims that are included in this case before this court. And that's where the Court of Appeals comes in later, and I'll address that momentarily. Your Honor, with all respect to these guys, as they're friends of mine, it's disingenuous, if not touching on being misleading on the part of the defendants and the company, to argue that this case involves the same parties, facts, and issues that were decided in a divorce case. A little timeline, Judge, that I think puts things in perspective. The divorce decree was actually signed by Judge Francis Harris on October 22, 2019, and the Honorable Ashley Wysocki on October 24, 2019. On October 29, Judge, 5 days later, Gail brought this suit against Cliff, Usilac, and Teal for breach of fiduciary duties and other torts, which she had reserved on the record to do, which I'll address in a moment, and the court gave her permission to do that. On October 29th.
Exactly Mr. Godwin, can I see exactly what happened in that transcript so I understand what the reservation was and how it worked? I'm not sure I fully get that.
Well, what the reservation, Your Honor, was Ike Van den Eyck was representing Gail and the divorce action judge. And he stated in open court and that he wanted to reserve the right to bring tort claims against Cliff and others as a result of the agreements that had been entered into by Cliff regarding these officers. The court stated, I understand you, Mr. Van den Eyck, have reserved your claim for Mrs. Fischer against Mr. Fischer, alleging that he breached his fiduciary duty to her into entering into these agreements, at least those done after 2008 and the signature of the postnuptial agreement. He reserved that on the record, Your Honor, to do that at a later date because he was not a part of the divorce proceeding. Your Honor, the Court of Appeals going back, they decided on August 11 that all of the claims that they transferred all claims that Gail, the company, or Cliff have asserted that do not seek enforcement of the divorce decree. Judge, the significance of that in part is that by transferring Gail's corporate claims, the Court of Appeals deemed those claims existing and viable, and thus negating any credible res judicata argument. Otherwise, they wouldn't have said you're going to transfer back to Judge Hoffman's court all of the claims if they thought they should have been disposed of in the family court. It would have made no sense. They didn't do that. They transferred everything back that did not involve a enforcement of the divorce decree. Judge, let me address the principles of res judicata. Res judicata is inapplicable to any of Gail's corporate claims. Element 1, Your Honor, there was no prior final judgment on the merits of any of the claims brought before this court, and the family court was not a court of competent jurisdiction to hear Gail's corporate claims. The Court of Appeals said that in their opinion on August 11. Your Honor, the movement must provide proof of the final judgment and pleadings from the prior suit, citing there the In Re JGW case. They cannot do that. In the JGW case, Your Honor, the court held that a remote reference of possible tort claims the husband sought was mentioned in the divorce did not establish that the tort claims had been previously litigated. Your Honor, in Daniels versus MTI Inc., the court held that a prior divorce action did not preclude the second action brought by the former wife. against her former husband for breach of fiduciary duty and a breach of a limited partnership agreement.
Let me ask you this, Mr.
Order,
Godwin.
please.
What were, I want to make sure I understand the timeline here. Were the claims, the other side seems to say that all of the corporate claims that were made in the, I guess with the exception of the ones involving the corporate Tuzalek and the other guy, that all of those claims were brought in the pleadings in the prior case prior to the judgment. Is that accurate or not, or how do they correspond to what's in my case?
Your Honor, they were not brought in, the corporate claims that are before your Honor in your court were not brought in the prior case. They know that, the documents show that, they simply were not brought there. And the items, the matters that were before the family court involve the division of the marital estate. Plain and simple. It didn't involve any breaches of fiduciary duty of any claims against Cliff or Larry Teal or Ted Uzelak.
Who's the family law lawyer that was here again? What was his, Mr. Epstein?
Mr. Epstein.
Good morning, Your Honor.
Mr. Epstein, were these claims, these corporate claims, pled in the original lawsuit, original family law lawsuit when the final judgment was entered? Were those claims in there?
There were breaches of fiduciary duty that were alleged by both spouses in the divorce, Your Honor.
And
That's
all
not
the
true,
other
Judge.
claims?
That's not true. Gail Fisher did not allege any breaches of fiduciary duty, and the only breach of fiduciary duty that Cliff Fisher brought forward in the divorce case related to a waste of a community property. Had
With all due
nothing to
respect,
do with the corporation.
with all due respect to Mr. Godwin, who is not at the divorce trial, and I was, Gail Fisher brought in her response to Mr. Lowensen's suit on behalf of the corporation in the divorce trial, Gail Fisher alleged breach of fiduciary duty in her response to that suit.
Judge, the pleadings will speak for themselves, and the transcript is there. And I've read it, I've gone through it, I've looked at the pleadings, and the
Can
issue.
someone tell me what I think a key issue here, in my mind at least, is which exhibit number details the live pleadings at the time for both sides at the time the judgment was entered? Which pleading in the family court? Which exhibit numbers?
Somebody will help me with that, Your Honor. They'll pull what?
Or they can share screen it or however you want to do
You have
it. So
that.
if someone could share screen
Find that.
those, that'd be great.
Seymour, can you find those?
Can you share a screen on that, Kristen?
Mariam, let's bring up the counterclaim response.
Okay,
And what exhibit number is
Kristen.
that, Seymour, for the court's benefit?
I'll get that.
You know, put that screen up.
I don't care who does it. I just want to see it. And I particularly want to see Gail's pleadings, live pleadings at the time the agreed judgment was entered.
We got to bring up the counterclaim response. I'm going to find the exhibit.
I can't share my screen.
Again?
It doesn't, it says it's disabled.
Oh, it's the, I've enabled it. It was already enabled.
The counterclaim
Let me try
response is, the counterclaim response is our exhibit 29.
Okay, give me a
Have it
second.
work. Judge, we can't seem to find it here. What I would suggest, if it makes sense to you, we can try to dig around and find it. Seymour's trying as well. I can go ahead and present my arguments. We can email that to you in the form of a
I
complete.
mean, if it's, I can read it myself. Let me see if I can pull it up.
Okay, find it. Okay.
You can proceed, Mr. Godwin.
Thank you, Judge. Your Honor, and we're continuing to look forward here as well. I think Seymour as well. Judge, This case, Your Honor, does not establish the existence of a prior final judgment on the merits, as it is based on entirely different claims and causes of action than the divorce. Your Honor, the divorce decree spoke strictly to the separation of property owned by the parties, including the shares of stock in the company, the Fischer Company. Judge, just like in JGW's case, holding that a remote reference to an additional tort claim was mentioned in the divorce did not establish that those claims had previously been litigated, Gail's divorce from Cliff could not have included, let alone rendered a final judgment on the merits of her corporate claim, because they were not pled. Furthermore, Your Honor, in the 254th District Court, it was not a court of competent jurisdiction for Gail's corporate claims, and the Court of Appeals has said that in its opinion. It is clear that a divorce proceeding solely involved matters related to the division of the marital estate, and the divorce decree disposed of matters pertaining to division of the marital estate. Nothing more, Your Honor. Defendants in the company cite to Schoberg to claim that there is a final judgment on the merits in this instant case. However, it is important to note that Gail is not collaterally attacking the agreed judgment, Your Honor, related to the agreements, as the ex-wife and Schoberg had done by attacking the agreed validity. Rather, Gail is simply asserting that the agreed judgment and the divorce decree did not address Gail's pending corporate claims because it addressed only the matters relating to the marital estate, not any claims with regard to the company or Teal or Usilac. Second element, Your Honor, the only two parties to the divorce decree were Cliff and Gail Fischer as husband and wife. Res judicata, as Your Honor knows, requires mutuality of interest. Both parties must be the same as those in the first suit or in privity with them. A party appearing in one capacity, Your Honor, is not bound by res judicata when appearing in another capacity in a subsequent action. Privity, Your Honor, does not exist, and I'll speak to Teal and Usilac's lack of privity in a moment. Privity does not exist when persons are interested in the same question or proving the same facts, but requires an identity of interest in the legal right actually litigated, citing the Texas Real Estate Commission versus Nagel case in our papers. Likewise, Cliff appearing in his capacity as Gail's husband in the divorce case, Your Honor, is not the same as Cliff appearing in his capacity as the owner, director, employee, or officer of the company of the corporate lawsuit, which he brought himself, Your Honor, in your court. If he believed that he had already had those claims disposed of in the family court, why would he be bringing them in October of 2019 in your court? Your Honor, in Garcia, the Texas Supreme Court, Garcia versus R.C. Cola, our Texas Supreme Court held that when a party has a claim in both her individual and representative capacities, a judgment for or against the party in one capacity does not later bar suit in which the party is involved in another capacity. Likewise, Your Honor, Usilac and Teal are not in privity, whether individually or in representative capacity, to the divorce case. Usilac and Teal's mere participation as employees of the company does not establish privity with the company or the divorce case, plain and simple. Your Honor, Gail could not have been interested in the same question or proving the same facts during the divorce case with her corporate claims, as the issues in the divorce case were related, again, as I said, simply to divide the assets of the parties. They were alleging that there were irreconcilable differences. It really wasn't an issue over the fault in the divorce at that time. Whereas, Your Honor, in the corporate case, Gail is not appearing as an ex-wife, but as an owner, a 50% owner in her individual separate property capacity. an employee, an officer of the company, and in that capacity, she's seeking a judgment against Cliff, Uzelak, and Teal for their wrongs committed in their corporate capacities and not Cliff in his marital capacity. Element 3, Your Honor, as to why res judicata should be disposed of. The claims in the corporate lawsuit could not have been raised, let alone litigated in a divorce case. A subsequent suit will be barred, Your Honor, if it arises out of the same subject matter of a previous suit and which, through the exercise of due diligence, could have been litigated in a prior suit. We know that. That's axiomatic. A determination of what constitutes the subject matter of a suit necessarily requires an examination of the factual basis of the claims in the prior litigation.
Mr. Godwin,
Yes, Your Honor.
so this is, I believe, Exhibit 29. Is this what you were referring to, Mr. Roberts?
Yes, and if you will go to page 4, Judge,
That's it.
the first
Okay.
full paragraph, you'll see, there we go.
Live pleading.
If you'll
Judge,
see,
this is not Gail's live pleading.
well, it was live at the time of the agreed judgment. And if you
What
go,
Gail,
as
what I understood Your Honor asked for was the live pleading of Gail at the time that when the case was concluded, when it went to trial. What was the live pleading?
And here it is.
Well,
And if we,
just to say, let me hear from Mr. Roberts and I'll hear from Mr. Godwin. So, Mr.
all right, if you go, Judge, to page 4 of that document, the full paragraph on page 4, which begins, Gail Fischer, you'll see several allegations of a breach of fiduciary duty against Cliff. This is not a remote reference, Judge. This is a specific allegation against Cliff for breaching his fiduciary duty against her. And not only is it on page...
Okay, but this is clearly not this is a response to a application for counterclaims and application for permanent injunction. She's not pleading breach of fiduciary duty here.
Well,
Right.
Judge, we're in a notice pleading state. And she, as I said, this is not a tangential off the cuff remark. She's making specific allegations of breach of fiduciary duty, which shows, Judge, that she knew she had those claims. You can also see that not only on page 4, but at the top of page 12. You go to the top of page 12, you can see that. And the point that we're making with res judicata, Judge, is at the top of page 12, she talks about breach of fiduciary duty. The point about res judicata is if you know you have claims and claims are being litigated, you got to bring them. And she had a chance to bring them right here and there. She knew she had claims for breach of fiduciary
There's two
duty.
issues here, though, Mr. Roberts. One is, did she bring the claims? That is not a claim for breach of fiduciary duty. If that's what you're relying on, in my opinion, that's not a claim. Could she have brought it in this court? I think that's questionable. Should she have brought it in this court? That's maybe questionable, but I don't see, if that's what you're relying on, Exhibit 29, that is not sufficient to make a claim. That is not a breach of fiduciary claim. That is not a, so if is that what you're relying on to argue that she had made all of these claims before in the original lawsuit?
That is what we are. The answer is yes.
Okay.
On that, is that she brought the claims.
I just want to make sure that's what you're relying on. If that's it, then clearly she did not make a claim, a breach of fiduciary claim or a fraud claim or any of the other claims that they're making in this suit, if that's what you're relying on. So should she have made it? Arguable. Could she have made it? I'm not sure she could, but maybe, but in my opinion, she did not. But let's go ahead and, Mr. Godwin, you can respond if you want to. I don't know if it's a good idea, but you can respond to that if you'd like.
Well, I think you've stated it more accurately and even more correctly than I could, Judge.
I appreciate that.
She did not bring those, thank you, Judge. She did not bring those claims in a divorce action. And they know it, and they sued her for all these corporate claims over in not only the family court, but also in your court. They sued first in October in the family court, and they filed the exact same pleadings in your court in December 2019. So they know these issues had not been disposed of, that they were suing her over and she was suing them over, involving corporate issues, not the marital estate, Your Honor. So I'll go back now. I think you saw the point. You addressed it very well. And with your permission, Your Honor, I'll continue my argument, try to get through.
How much time does Mr. Godwin have left?
28 minutes.
8
How much time? 8 minutes?
8 minutes, sir.
Oh, I
Okay,
thought
have
you
8
said
minutes.
28, Judge.
No, you only had 35 to start, so.
Well, I understand. Let me try to get done here in about 8 or so minutes if I can, Judge.
Okay.
Thank you very much, Your Honor. Your Honor, if unlitigated claims are not essentially connected to the litigated claims and they are not barred by res judicata, we all know that. Contrary to what defendants and the company would have this court believe, Gail's corporate claims are not essentially connected to the divorce, which had the primary objective of solely dividing marital property. Similarly, another court found that claims essentially arising out of the same conduct and seek largely in part the same damages are not barred by res judicata. Your Honor, Gail's corporate claims are not barred by res judicata very simply. The facts sought to be litigated in the corporate lawsuit were not mentioned, let alone litigated in the divorce case. Element 2, Your Honor, the facts sought to be litigated in the corporate lawsuit were not essential to the judgment in the divorce case, which simply divided the assets of the parties, including the one large asset was the company. Your Honor, in determining whether a fact issue is essential to a judgment, courts look to the factual determinations made by the trier of fact that are necessary to form the basis of the judgment. Specifically, a simple reading of Gail's petition, which you have referred to, Judge, in this case, and the divorce case will show this, that they were not related. Your Honor, defendants and the company erroneously claim that Lacey, a factually distinguishable case, is somehow directly on point. Lacey was a Fifth Circuit, a Court of Appeals opinion out of Dallas. Unlike Lacey, Your Honor, the agreed judgment did not recite that all matters in controversy were submitted to the court and the case proceeded to trial. Here, Your Honor, there was no mention of any of the matters in controversy being submitted to the court that proceeded to trial. And even if they were, those matters in controversy, again, were limited solely to a division of the marital estate and not any resolution of any of the corporate claims as we know them. Uselak and Teal mistakenly believe that the corporate claims were actually litigated in the divorce case. How will they know they weren't there, Your Honor? Mr. Lowenson has acknowledged that. Your Honor, Cliff and the company wholly misrepresent to this court, to Your Honor, the purpose of these separate agreements to erroneously assert that the facts in those agreements were essential to the judgment in the divorce. That's not so. First, the MSJ order was not supported by any determination on the pleading, on the pending facts before concerning fraud, as well as the encumbrance of Gail's property rights and compensation presently before this court, which we brought before Your Honor. It was not in the family court. Second, Gail was not and is not challenging the agreed judgment. In essence, Gail is challenging the effect that the documents within the agreed judgment would have on her rights in the company to her 50%. Lastly, Your Honor, the agreements were not based on facts that were essential to the judgment in the divorce. Gail brought this lawsuit to seek certain corporate causes of action against Cliff, Larry Teal, Ted Uselak, but those issues were not litigated in the divorce court. Your Honor, going over here, Seymour talked about judicial admissions. Judicial admissions are irrelevant for summary judgment purposes, as you know, and even if admissions were made, they apply to statements of fact, not conclusions of law. A judicial admission is a statement of fact in a court proceeding by a court. Statements of law and legal conclusions do not constitute judicial admissions. Defendants in the company mistakenly cite the court to Cortez versus Liberty Mutual Insurance to state that a judicial admission can be made to an agreed judgment. They suggest, Your Honor, erroneously, that Gale's statements that the agreements are valid, enforceable, and that Cliff had apparently authority to enter the agreements are judicial admissions and enforceable via an agreed judgment. While Gale is not disputing, Your Honor, the agreed judgment, even if she were, whether the agreements are valid and enforceable and whether Cliff had apparent authority are all conclusions of law, not fact. Accordingly, because judicial admissions apply to statements of fact and not conclusions of law, there are no judicial admissions to serve as a basis for her summary judgment or the summary judgment against her as a matter of law. I don't know why they brought that up. Dealing with the issue, Your Honor, Seymour brought up the issue about a bill of review. I can't imagine why anybody would be bringing that up as a ground for a summary judgment based on preclusion doctrines, on doctrines, on res judicata. Your Honor, you know a bill of review is an independent action to set aside a judgment that is no longer appealable or subject to challenge by a motion for new trial, citing the Wembley case out of our Texas Supreme Court. The mention of a bill of review is nothing more than a last-ditch effort to suggest that Gale should have taken certain legal action, which he failed to take. I haven't failed to take any action, Your Honor, and the suggestion that I have is a repugnant thought, and it not only is embarrassing to me, but it's an affront to me that they would suggest that I haven't done something I should have done. Yet there are no requirements or need to file a bill of review following the divorce, and any application by Cliff and the company of the legal doctrine is contrary to clear, unambiguous law. These same guys that would complain now that I should have filed a bill of review are asking you in essence to say Ike Van Eyck committed legal malpractice by not bringing claims in the divorce action. They won't say it by name, but that's what they're asking you to do, is to say he should have brought all of those there, which he should not have. And so because of that, he committed malpractice. And that
I'll say this, I agree with you on that point. That point is pretty crystal clear to me that's not grounds for summary judgment. I'm not sure that's really even intended to be grounds. Maybe
that's ridiculous.
Yeah.
To suggest that about
I will, just to kind of clear things up a little bit, I'm going to deny the summary judgment on that grounds. As to the claims for that a bill of review should have been filed, that somehow that's.
Thank you, Your Honor.
It's not a grounds for summary judgment.
Thank you very much, Judge. Judge, I'm gonna wind it up here in conclusion. You know where this thing is. You've seen it. You've seen, again, as I said, this is throw it up and see what'll stick. We talking about bill of review. We talking about, malpractice against Ike Van Eyck, malpractice against me. All of that's nonsense. See what'll stick. I would think more of these lawyers. Judge, the defendants in the company's contentions merely aver that had Gale litigated or could have litigated her corporate claims in the divorce without even acknowledging that res judicata does not bar any of Gale's corporate claims as they exist and occurred outside of the divorce. And they were not actually litigated in divorce, nor were they required to be. That divorce, Judge, was solely about dividing the millions and millions and millions of dollars that these people accumulated through their mutual hard work and efforts. And we recognize that. To hold otherwise, Your Honor, would be contrary to Texas law and the explicit terms of the divorce decree, which were limited to the separation of the marital estate. Such limitations have further been confirmed by our very own Court of Appeals. You saw the opinion.
Mr. Godwin, you're out of time as well. So
I'll ask that the court deny the summary judgment of all of the parties, Your Honor. That is the company, Cliff Fischer, Larry Teal, and Ted Uzelak in their entirety. Thank you very much for your time, Judge.
All right, any last minute comments anybody wants to make briefly before?
Yes, Judge. I want to point out a few things. In the transcript, which we've attached as Exhibit 1 to our reply, you'll see that Mr. Godwin read a quote about the stipulation, the so-called stipulation. What he didn't read, Judge, was Mr. Epstein not agreeing to it. Because after the judge made her statement, Mr. Epstein says, Your Honor, I'd like to clarify, there's no pleading on file for breach of fiduciary duty that Gail is alleging. So the fact that the court asked a question does not constitute a stipulation. Second, the court, Mr. Godwin says that the divorce was about just the division of the marital
When was that
property.
reply filed?
What?
When
It was
the-
filed last week, Judge, on the deadline.
What date?
I think it was Thursday or Friday.
Friday.
But I had my, that's attached.
Let me just share screen so you can maybe show me where it's filed, because I don't know that it wasn't included in the binder you guys sent, right?
No, that's right, Judge. The binder we sent was as a result of the first hearing we were going to have. When we reset it, I filed the reply on Friday, which was the deadline, and I included it in an email to Ms. Pinson yesterday.
Do you see where it is here? I don't remember seeing it. I looked at this yesterday. Do you see the reply that you're talking about?
Well, if we can just get to a date, which is yesterday. I mean, which was Friday.
Well, it's 11, 10, 9, 8. So the 8th, is that?
Yeah. Well, it wasn't, and it may not have been. It was filed on Friday. I don't know when it was date stamped. That's the problem.
Oh, just.
So it's going to be it's going to be after the 4th. This is the 4th.
Do you see it anywhere in here?
Well, we're going so quickly.
Sorry.
You don't see where it was received either on the screen
10, wait a minute.
on your docket.
10, motion. 10, motion.
Maybe it's this. Maybe this is it. Maybe just. There it is.
Yep.
Is this what you're talking about?
Yeah, that's what I'm talking about.
Okay, I have not seen this. So you said that there's a transcript.
Transcript is attached to that. The transcript of the second day of the divorce action.
If you think about it, Your Honor, it really doesn't matter if the court recognized that Gail Fisher's
Okay,
lawyer
and you're gonna
reserved the
go to-
right to
you're gonna go to
reserve the
page-
right to bring the claim.
You're going to go to page 11 of the transcript.
So what?
You're going to go to page 11 of the transcript.
Okay.
And then,
What's that?
okay, there you go. The first paragraph, which is highlighted, is the judge asking, is there a reservation of rights? And then you will see Mr. Epstein say, oh, Your Honor, I'd like to clarify, there's no pleading on file for breach of fiduciary duty that Gail is alleging. So there is no stipulation that Gail is able to file her lawsuit for breach of fiduciary duty later.
Well, Judge,
To the extent that Mr. Godwin, to the extent that Mr. Godwin is to the extent that Mr. Godwin is relying on such a stipulation, there is no stipulation.
Look at page 11, Judge, where Seymour had it there and then flipped it off, where the court said there, the court, no, I will accept your stipulation. Look at line 8. That's the stipulation that was made and the court accepted it.
Yes, and below that, Mr. Epstein clarified it.
Well, the court accepted the stipulation, Your Honor, that Mr. Roberts just said did not exist.
If you read the entirety of what I have provided, you'll see that there is no stipulation. And the second point that Mr. Godwin is making is that the divorce actually only dealt with between the division of the marital property, ignores the fact that Gail brought in the company as a necessary and indispensable third party, and the company sued her in a deck action. So the divorce included more than what Mr. Godwin is saying. If you go, Judge, to page 14, you'll see the end of the stipulation discussion. You'll see the end of the stipulation. I would say, here's what Mr. Epstein says. I would say that they are prohibited from making that decision because they haven't properly pled for breach of fiduciary duty claim. It is not before the court. And Your Honor, again, it's not an obligation against Mr. Fisher's 50%. And Mr. Vanden Eyck agrees with Robert Epstein. I agree, Your Honor. The issue before the court was, where does the change in control bonus money come from? That's what they were arguing over. And they agreed that it came out of the company, not out of Cliff's share of the company. So this is really has nothing, there was no stipulation there for Gail to reserve her right.
And Your Honor, we don't challenge that part of it. We're simply saying that there were no claims in the divorce case revolving anything other than dividing the marital estate. These claims that we have brought and that the company and Cliff Fisher have brought against Gail all involve what we've all referred to as the corporate claims in your court. The Court of Appeals saw those as viable claims when they wrote their opinion and said only the matters involving the enforcement of the decree will stay with the divorce court. Everything else will go back to the 68th District Court. They recognize the validity of the claims, Your Honor.
May I say one thing, Your Honor?
Go ahead.
What Mr. Godwin just said is not correct when he says the only issues in the divorce case were the division of marital assets. I filed a counterclaim on behalf of the company asking for a declaratory judgment that all of these agreements that he is now suing on in your case and claiming it's a breach of fiduciary duty to enter into them and to carry them out, that all of those agreements were valid, proper, and enforceable. And Gail entered into an agreed judgment in the divorce case, establishing that my declaratory judgment was true. So those claims not only were present in the divorce case, they were the subject of an agreed judgment in the divorce case. And now what Mr. Godwin wants to do is turn around and sue my clients and sue Cliff Fisher and sue the company for breach of fiduciary duty for entering into and carrying out those same agreements that were litigated in the divorce action and agreed to as enforceable, valid agreements. Thank you, Your Honor.
Your Honor, let me say very briefly to Mr. Lowensen's point there. We're not challenging the agreements, Your Honor, in this lawsuit. The agreements were not based on facts that were essential to the judgment in the divorce case. Gail brought forth this lawsuit to seek certain corporate causes of action against Cliff and others, but those issues were not litigated in any way in the divorce case. They can paint it as many ways as they want to paint it, but they were simply not litigated at all in the divorce court. They simply were not, Your Honor.
Well,
Yes, but if you look at the pleadings that Mr. Godwin filed, you'll see that they relate to a time period that predates the divorce decree. And the point that we're making is not only were those issues a part of the litigation in reaching the agreed judgment, but they should have been litigated had they not been. Mr. Lowensen makes a very valid point. The declaratory judgment action he raised brought those issues before the court.
And Your Honor, I don't know what it means when Mr. Godwin says they weren't litigated. What I do know is a claim was filed relating to those agreements in the divorce case. Depositions were taken. We started a trial. Witnesses were called. And when I was set to cross-examine Gail after she testified on direct about those agreements and her complaints about them, right before my cross-examination was to start, that's when discussions occurred off the record, which ultimately led to the agreed judgment. So they were litigated. It's just that she gave up in the course of the litigation and agreed that those agreements were valid. I think that's being litigated. They weren't litigated in the sense that there was a parties continued to fight about it, but they entered into a judgment about it. When Mr. Godwin says, we're not contesting those agreements, how can you say, on the one hand, an agreement is valid and it entered into a judgment in that effect, valid and proper, and then come back and file a new lawsuit and say, It was a breach of fiduciary duty for you to enter into those agreements, and it's been a breach of fiduciary duty for you to pay money under those agreements. That just makes no sense.
Your Honor, those claims were not litigated in the family court. They simply were not. And Mr. Roberts' argument that, well, they were in the same time frame. The fact something may have occurred in the same time frame doesn't mean at all that it was litigated or should have been litigated in the earlier action, Your Honor. That action in the family court, they can talk until the end of the world goes flat. That action was simply limited to dividing the assets of the parties. The Court of Appeals made it very clear. The Court of Appeals is going to allow the family court to keep are matters that relate to the enforcement of the decree. All other matters, and they had those pleadings, Judge, before them. The Court of Appeals had those pleadings. All other matters will go back to Judge Hoffman's court. Again, as I said, if they didn't think they were viable and already been disposed of, they would not have said they would go back to Your Honor's court. Now, we can stand here and then talk around circles all day long, but that's the effect of it at the end of the argument, at the end of the day.
Your
All right,
Honor,
guys, thank you so much for your argument. This was great briefing. I enjoyed this argument. I'm going to try to make a decision prior to the next hearing, which remind me again when that hearing is.
Judge, you've got a hearing on, I think, July 14th.
Okay.
The enforcement.
So it'll be what? Okay, I'm going to get a decision within the next month on this.
And you've already
Good job
granted
by
summary
everybody.
judgment.
Thank you, sir. I'm
You've already
sorry.
granted summary judgment on part of it, Your Honor. That is on the part about what should have been pled in the family court. Would you
Right.
clarify again?
So I ruled on the bill of review that would be some grounds for summary judgment, that particular grounds is I'm granting summary judgment, or I'm denying, I guess, summary judgment on that grounds.
Are you also denying it, Your Honor? And thank you for that, because that goes direct at me. Are you also denying it where they're complaining that Van and Eichel should have filed pleadings and indirectly accusing him of malpractice as well?
I don't think that was part of it, but what I said earlier, and I've also that I don't know if this is a grounds, but I've found that, and I think it's confirmed in that transcript you guys just showed, is that this was never pled in the prior suit. So that isn't a grounds for summary judgment. I've just found that that's going to be part of my analysis in this. I'm not making a decision today, but these claims by Gail were clearly not brought in the previous lawsuit. So should they have been, could they have been, that stuff I need to kind of analyze, but they were clearly not brought in the previous suit. And that was actually stated by, it looks like Mr. Epstein in that transcript, they weren't brought. And in the pleadings you've showed me clarify they were not brought. So, but that's not necessarily dispositive, but it is something we need to look at. All right, guys. I will get you the decision. Have you guys all each provided proposed orders for me?
I have, Judge.
We have as well, Judge.
Okay.
We haven't, we will.
Great. All right, guys. Thank you so much. Thank you for your argument. Good job by everybody. And we'll get you a decision as soon as we can, but it'll probably
Thank you, Your Honor.
Thank you, guys.
Thank
Bye-bye.
you.